So I've decided that we're going to do a multi-episode deep dive into a particular document that should give us a lot of context for future conversations. So this is sort of laying the groundwork for what will come, okay? Because I truly do believe that both on the prosecutorial side and on the defense side, I believe the attorneys have all not lived up to their professional responsibilities. Okay. So, anyhow, what we're going to be taking a look at to help us to begin to lay the groundwork are the Indiana rules of professional conduct. Okay. Now, you may ask, well, what is that, Prof? Well, the Indiana rules for professional conduct they pretty much establish the ethical and professional standards for lawyers practicing in the state of Indiana. These are very similar or derivative of the model rules of professional conduct by the American Bar Association. They cover a wide variety of topics, including competence, diligence, confidentiality, conflict of interest, fees, communications, publicity, trial conduct, safekeeping, restrictions, all of this. Okay. So tonight we're going to begin our journey into a review of the Indiana rules of professional conduct that govern the attorney's ethical behaviors. Okay. And part of the reason for doing that is we want to get a good understanding of what kind of guidelines exist in the state of Indiana for practicing attorneys, because we want to be able to understand what we need to be looking for as far as anyone stepping outside of the bounds of these rules of professional conduct. Okay, so that's my goal, and it appears that I can't handle myself tonight. I keep dropping things, but that's what we're going to be diving into tonight. Is our first portion of the rules of professional conduct for attorneys here. And so hopefully if you're sticking around, you got your listening ears on and maybe something to drink, and we'll just be able to listen as we read through the beginning section of this. And like I said, it may take us a few episodes to get through it all because this is quite a hefty document. But like I said, this will lay the groundwork for our understanding of what we should be expecting from all attorneys touching the Delphi case or the Rick Allen case in this particular instance, okay? So let us get started here. So you see, this is the preamble here to the document, and it's called A Lawyer's Responsibilities. A lawyer, as a member of the legal profession, is representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. Whether or not engaging in the practice of law, lawyers should conduct themselves honorably. As a representative of clients, a lawyer performs functions. As an advisor, a lawyer provides a client with an informed understanding of the client's legal rights and obligations and explains their practical implications. As an advocate, a lawyer asserts the client's position under the rules of the adversary system. As a negotiator, a lawyer seeks a result advantageous to the client, but consistent with the requirements of honest dealings with others. As an intermediary between clients, a lawyer seeks to reconcile their divergent interests as an advisor and to a limited extent as a spokesperson for each client. As an evaluator, a lawyer acts by examining a client's legal affairs and reporting about them to the client or to others. In addition to these representational functions, a lawyer may serve as a third-party neutral, a non-representational role, helping the parties to resolve a dispute or other matter. Some of these rules apply directly to lawyers who are or have served as third-party neutrals. See, for example, rules 1.12 and 2.4. In addition, there are rules that apply to lawyers who are not active in the practice of law or to practicing lawyers even when they are acting in a non-professional capacity. That's a very important one. So listen to that again. I'll read it again because it matters. In addition, there are rules that apply to lawyers who are not active in the practice of law or to practicing lawyers even when they are acting in a non-professional capacity. So do you hear that? That there are rules that apply to lawyers regardless whether or not they are practicing or acting in a professional capacity at any moment. Okay? That's to keep in mind for the future. Remember, we're reviewing these to build the groundwork for our understanding of evaluating all the attorneys who've touched this case, various actions or inactions, and vice versa. For example, a lawyer who commits fraud in the conduct of a business is subject to discipline for engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. See Rule 8.4. In all professional functions, a lawyer should be competent, prompt, and diligent. A lawyer should maintain communication with the client concerning the representation. A lawyer should keep in confidence information relating to the representation of a client, except so far as disclosure is required or permitted by the rules of professional conduct or other law. A lawyer's conduct should conform to the requirements of the law, both in professional service to clients and in the lawyer's business and personal affairs. That's another one. Look at that one. A lawyer's conduct should conform to the requirements of law, both in professional service to clients and in the lawyer's business and personal affairs. A lawyer should use the law's procedures only for legitimate purposes and not to harass or intimidate others. A lawyer should demonstrate respect for the legal system and for those who serve it, including judges, other lawyers, and public officials. While it is a lawyer's duty, when necessary, to challenge the rectitude of official action, it is also a lawyer's duty to uphold legal process. As a public citizen, a lawyer should seek improvement of the law, access to the legal system, and administration of justice, and the quality of service rendered by the legal profession. As a member of a learned profession, a lawyer should cultivate knowledge of the law beyond its use for clients and employ that knowledge in reform of the law and work to strengthen legal education. In addition, a lawyer should further the public's understanding of and confidence in the rule of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. A lawyer should be mindful of deficiencies in the administration of justice and of the fact that the poor, and sometimes persons who are not poor, cannot afford adequate legal assistance. Therefore, all lawyers should devote professional time and resources and use civic influence to ensure equal access to our system of justice for all those who, because of economic or social barriers, cannot afford or secure adequate legal counsel. A lawyer should aid in the public or in the legal profession in pursuing these objectives and should help the bar regulate itself in the public interest. Many of a lawyer's professional responsibilities are prescribed in the rules of professional conduct. as well as substantive and procedural law. However, a lawyer is also guided by personal conscience and the appropriate approbation of professional peers. A lawyer should strive to attain the highest level of skill and to improve the law and the legal professional to exemplify the legal profession's ideals of public service. A lawyer's responsibilities as a representative of clients, an officer of the legal system, and a public citizen are usually harmonious. Thus, when an opposing party is well represented, a lawyer can be an effective advocate on behalf of a client and at the same time assume that justice is being done. Also, a lawyer can be sure that preserving client confidence ordinarily serves the public interest because people are more likely to seek legal advice and thereby heed their legal obligations when they know their communications will be private. In the nature of law practice, however, conflicting responsibilities are encountered. Virtually all difficult ethical problems arise from conflict between a lawyer's responsibilities to clients, to the legal system, and to the lawyer's own interest in remaining an ethical person while earning a satisfactory living. Let's read that again because it's important. It's pertinent. In the nature of law practice, conflicting responsibilities are encountered. Virtually all difficult ethical problems arise from the conflict between a lawyer's responsibilities to the clients, to the legal system, and to the lawyer's own interest in remaining an ethical person while earning a satisfactory living. Ooh, that's rough. That's rough. The rules of professional conduct often prescribe terms for resolving such conflicts. Within the framework of these rules, however, many difficult issues of professional discretion can arise. Such issues must be resolved through the exercise of sensitive professional and moral judgment, guided by the basic principles underlying the rules. These principles include the lawyer's obligation to protect and pursue a client's legitimate interests within the bounds of law, while maintaining a professional, courteous, and civil attitude toward all persons involved in the legal system. The legal profession is largely self-governing. Although other professions have been granted the power, also have been granted powers of self-government, the legal profession is unique in this respect because of the close relationship between the profession and the process of government and law enforcement. This connection is manifested in the fact that ultimate authority over the legal profession is vested largely in the courts. To the extent that lawyers meet the obligations of their professional calling, the occasion for government regulation is obviated. Self-regulation also helps maintain the legal profession's independence from government domination. An independent legal profession is an important force in preserving government under law, for abuse of legal authority is more readily challenged by a profession whose members are not dependent on government for the right to practice. The legal profession's relative autonomy carries with it special responsibilities of self-government. The legal profession has the responsibility to assure that its regulations are conceived in the public interest and not in the furtherance of parochial or self-interested concerns of the bar. Every lawyer is responsible for observance of the rules of professional conduct. A lawyer should also aid in securing their observance by other lawyers. Neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. Lawyers play a vital role in the preservation of society. The fulfillment of this role requires an understanding by lawyers of their relationship to our legal system. The rules of professional conduct, when properly applied, serve to define that relationship. Scope. The rules of professional conduct are rules of reason. They should be interpreted with reference to the purposes of legal representation and of the law itself. Some of the rules are imperatives, cast in terms of shall or shall not. These define proper conduct for purposes of professional discipline. Others, generally cast in the term may, are permissive and define areas under the rules in which the lawyer has discretion to exercise professional judgment. No disciplinary action should be taken when the lawyer chooses not to act or acts within the bounds of such discretion. Other rules define the nature of relationships between the lawyer and others. These rules are thus partly obligatory and disciplinary, and partly constitutive and descriptive in that they define a lawyer's professional role. Many of the comments use the term should. Comments do not add obligations to the rules, but provide guidance for practicing in compliance with the rules. The rules presuppose a larger legal context shaping a lawyer's role. That context includes court rules and statutes relating to matters of licensure, laws defining specific obligations of lawyers, and substantive and procedural law in general. The comments are sometimes used to alert lawyers to their responsibilities under such other law. Compliance with the rules, as with all law in an open society, depends primarily upon understanding and voluntary compliance. Secondarily, upon reinforcement by peer and public opinion. And finally, when necessary, upon enforcement through disciplinary proceedings. The rules do not, however, exhaust the moral and ethical considerations that should inform a lawyer. For no worthwhile human activity can be completely defined by legal rules. The rules simply provide a framework for the ethical practice of law. Furthermore, for purposes of determining the lawyer's authority and responsibility, principles of substantive law external to these rules determine whether a client-lawyer relationship exists. Most of the duties flowing from the client-lawyer relationship attach only after the client has requested the lawyer to render legal services, and the lawyer has agreed to do so. But there are some duties, such as that of confidentiality under Rule 1.6, that attach when the lawyer agrees to consider whether a client-lawyer relationship shall be established. See Rule 1.18. Whether a client-lawyer relationship exists for any specific purpose can depend on the circumstances and may be a question of fact. Under various legal provisions, including constitutional, statutory, and common law, the responsibilities of government lawyers may include authority concerning legal matters that ordinarily reposes in the client in private client-lawyer relationships. For example, a lawyer for a government agency may have the authority on behalf of the government to decide upon settlement or whether to appeal from an adverse judgment. Such authority in various respects is generally vested in the Attorney General and the state's attorney in state government and their federal counterparts. And the same may be true of other government law officers. Also, lawyers under the supervision of these officers may be authorized to represent several government agencies in intergovernmental legal controversies in circumstances where a private lawyer could not represent multiple private clients. These rules do not abrogate any such authority. Failure to comply with an obligation or prohibition imposed by a rule is a basis for invoking the disciplinary process. Let's say that again. Failure to comply with an obligation or prohibition imposed by a rule is a basis for invoking the disciplinary process. The rules presuppose that disciplinary assessment of a lawyer's conduct will be made on the basis of facts and circumstances as they existed at the time of the conduct in question, and in recognition of the fact that a lawyer often has to act upon uncertain or incomplete evidence of the situation. Moreover, the rules presuppose that whether or not discipline should be imposed for a violation and the severity of a sanction depend on all the circumstances, such as the willfulness and seriousness of the violation, extenuating factors, and whether there have been previous violations. Violation of a rule should not itself give rise to a cause of action against a lawyer, nor should it create any presumption in such a case that a legal duty has been breached. In addition, violation of a rule does not necessarily warrant any other non-disciplinary remedy, such as disqualification of a lawyer in pending litigation. The rules are designed to provide guidance to lawyers and to provide a structure for regulating conduct through disciplinary agencies. They are not designed to be a basis for civil liability. But these rules may be used as non-conclusive evidence that a lawyer has breached a duty owed to a client. Furthermore, the purpose of the rules can be subverted when they are invoked by opposing parties as procedural weapons. The fact that a rule is a just basis for a lawyer's self-assessment or for sanctioning a lawyer under the administration of a disciplinary authority does not imply that an antagonist in a collateral proceeding or transaction has standing to seek enforcement of the rule. Nevertheless, since the rules do establish standards of conduct by lawyers, a lawyer's violation of a rule may be evidence of a breach of the applicable standard of conduct. The comment accompanying each rule explains and illustrates the meaning and purpose of the rule. The preamble and this note on scope provide general orientation. The comments are intended as guides to interpretation, but the text of each rule is authoritative. Again, the comments are intended as guides to interpretation, but the text of each rule is authoritative. Terminology. Belief or believes denotes that a person or the person involved actually supposed the fact in question to be true. A person's belief may be inferred from circumstances. Confirmed in writing, when used in reference to the informed consent of a person, denotes informed consent that is given in writing by the person or a writing that a lawyer promptly transmits to the person, confirming an oral informed consent. See paragraph N for the definition of writing. See paragraph E for the definition of informed consent. If it is not feasible to obtain or transmit the writing at the time the person gives informed consent, then the lawyer must obtain or transmit it within a reasonable time thereafter. Firm or law firm denotes a lawyer or lawyers in a law partnership, professional corporation, sole proprietorship, or other association authorized to practice law, or lawyers employed in a legal services organization or the legal department of a corporation or other organization. Fraud or fraudulent denotes conduct that is fraudulent under the substantive or procedural law of the applicable jurisdiction and has a purpose to deceive. Informed consent denotes the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risk of and reasonably available alternatives to the proposed course of conduct. Knowingly known or knows denotes actual knowledge of the fact in question. A person's knowledge may be inferred from circumstances. Partner denotes a member of a partnership, a shareholder in a law firm organized as a professional corporation, or a member of an association authorized to practice law. Reasonable or reasonably, when used in relation to conduct by a lawyer, denotes the conduct of a reasonably prudent and competent lawyer. Reasonable belief or reasonably believes, when used in reference to a lawyer, denotes that the lawyer believes the matter in question and that the circumstances are such that the belief is reasonable. Reasonably should know, when used in reference to a lawyer, denotes that a lawyer of reasonable prudence and competence would ascertain the matter in question. Screened denotes the isolation of a lawyer from any participation in a matter through the timely imposition of procedures within a firm that are reasonably adequate under the circumstances to protect information that the isolated lawyer is obligated to protect under the rules or these rules or other law. Substantial, when used in reference to degree or extent, denotes a material matter of clear and weighty importance. Tribunal denotes a court, an arbitrator, or any other neutral body or neutral individual making a decision based on evidence presented and the law applicable to that evidence, which decision is binding on the parties involved. Writing or written denotes a tangible or electronic record of a communication or representation, including handwriting, typewriting, printing, photostatting, photography, audio and video recording, or email. A signed writing includes an electronic sound, symbol, or process attached to or logically associated with a writing and executed or adopted by a person with the intent to sign the writing. Okay? We're going to skip over comments, okay? All of these will be available for you. I'm going to link this document down in the description below. Okay. All right, client-lawyer relationship. Here we go. We are now entering the actual rules of professional conduct, okay? Rule 1.1, competence. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Legal knowledge and skill. In determining whether a lawyer employs the requisite knowledge and skill in a particular matter, relevant factors include the relative complexity and specialized nature of the matter. Relevant factors include are the lawyer's general experience, the lawyer's training and experience in the field in question, the preparation and study the lawyer is able to give the matter, and whether it is feasible to refer the matter to or associate or consult with a lawyer of established competence in the field in question. In many instances, the required proficiency is that of a general practitioner. Expertise in a particular field of law may be required in some circumstances. A lawyer need not necessarily have special training or prior experience to handle legal problems of a type with which the lawyer is unfamiliar. A newly admitted lawyer can be as competent as a practitioner with long experience. Some important legal skills, such as the analysis of precedent, the evaluation of evidence, and legal drafting, are required in all legal problems. Perhaps the most fundamental legal skill consists of determining what kind of legal problems a situation may involve, a skill that necessarily transcends any particular specialized knowledge. A lawyer can provide adequate representation in a wholly novel field through necessary study. A competent representation can also be provided through the association of a lawyer of established competence in the field in question. In an emergency, a lawyer may give advice or assistance in a matter in which the lawyer does not have the skill ordinarily required, where referral to or consultation or association with another lawyer would be impractical. Even in an emergency, however, the assistance should be limited to that reasonably necessary in the circumstances. For Ill-considered action under emergency conditions can jeopardize the client's interest. A lawyer may accept representation where the requisite level of competence can be achieved by reasonable preparation. This applies as well to a lawyer who is appointed as counsel for an unrepresented person. See also Rule 6.2. Okay. All right, just a moment. All right, let's continue. Competent handling of a particular matter includes inquiry into and analysis of the factual and legal elements of the problem, and use of methods and procedures meeting the standards of competent practitioners. It also includes adequate preparation. The required attention and preparation are determined in part by what is at stake. Major litigation and complex transactions ordinarily require more extensive treatment than matters of lesser complexity and consequence. An agreement between the lawyer and the client regarding the scope of the representation may limit the matters for which the lawyer is responsible. To maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with the technology relevant to the lawyer's practice, engaging in continuing study and education, and comply with all continuing legal education requirements to which the lawyer is subject. Okay. Rule 1.2, scope of representation and allocation of authority between client and lawyer. Subject to paragraph C and D, a lawyer shall abide by a client's decisions concerning the objectives of representation, and as required by 1.4, shall consult with the client as to the means by which they are to be pursued. A lawyer may take such action on behalf of the client as is impliedly authorized to carry out the representation. A lawyer shall abide by a client's decision whether to settle a matter. In a criminal case, the lawyer shall abide by the client's decision after consultation with the lawyer as to a plea to be entered, whether to waive jury trial, and whether the client will testify. A lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. A lawyer may limit the scope and objectives of the representation if the limitation is reasonable under the circumstances and the client gives informed consent. Okay? A lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent, but a lawyer may discuss the legal consequences of any proposed course of conduct with the client, and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. Paragraph A confers upon the client the ultimate authority to determine the purposes to be served by legal representation, within the limits imposed by law and the lawyer's professional obligations. The decisions specified in paragraph A, such as whether to settle a civil matter, must also be made by the client. See Rule 1.4a, 1, for the lawyer's duty to communicate with the client about such decisions. With respect to the means by which the client's objectives are to be pursued, the lawyer shall consult with the client as required by Rule 1.4a2 and may take such action as impliedly authorized to carry out the representation. On occasion, however, a lawyer and client may disagree about the means used to accomplish the client's objectives. Clients normally defer to the special knowledge and skill of their lawyer with respect to the means to be used to accomplish their objectives, particularly with respect to technical, legal, and tactical matters. Conversely, lawyers usually defer to the client regarding such questions. As to the expense to be incurred and the concerns for third persons who might be adversely affected. Because of the varied nature of the matters about which a lawyer and client might disagree, and because the actions in question may implicate the interest of a tribunal or other persons, this rule does not prescribe how such disagreements are to be resolved. Other law, however, may be applicable and should be consulted by the lawyer. The lawyer should also consult with the client and seek a mutually acceptable resolution of the disagreement. If such efforts are unavailing and the lawyer has a fundamental disagreement with the client, the lawyer may withdraw from representation. See Rule 1.16b4. Conversely, the client may resolve the disagreement by discharging the lawyer. See Rule 1.16a3. At the outset of a representation, the client may authorize the lawyer to take specific action on the client's behalf without further consultation. Absent a material change in circumstance and subject to Rule 1.4, a lawyer may rely on such an advance authorization. The client may, however, revoke such an authority at any time. In a case in which the client appears to be suffering diminished capacity, the lawyer's duty to abide by the client's decisions is to be guided by reference to Rule 1.14. Independence from a client's views or activities. Legal representation should not be denied to people who are unable to afford legal services or whose cause is controversial or the subject of popular disapproval. By the same token, representing a client does not constitute approval of the client's views or activities. Agreements limiting scope of representation. The scope of services to be provided by a lawyer may be limited by agreement with the client or by terms under which the lawyer's services are made available to the client. When a lawyer has been retained by an insurer to represent an insured, for example, the representation may be limited to matters related to the insurance coverage. A limited representation may be appropriate because the client has limited objectives for the representation. In addition, the terms upon which representation is undertaken may exclude specific means that might otherwise be used to accomplish the client's objectives. Such limitations may exclude actions that the client thinks are too costly or that the lawyer regards as repugnant, unethical, or imprudent. Although this rule affords the lawyer and client substantial latitude to limit representation, the limitation must be reasonable under the circumstances. If, for example, a client's objective is limited to securing general information about the law the client needs in order to handle a common and typically uncomplicated legal problem, the lawyer and client may agree that the lawyer's services will be limited to a brief telephone consultation. Such a limitation, however, would not be reasonable if the time allotted was not sufficient to yield advice upon which the client could rely. Although an agreement for a limited representation does not exempt a lawyer from the duty to provide competent representation, the limitation is a factor to be considered when determining the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. See Rule 1.1. All agreements concerning a lawyer's representation of a client must accord with the rules of professional conduct and other law. Okay? Criminal, fraudulent, and prohibited transactions. Paragraph D prohibits a lawyer from knowingly counseling or assisting the client to commit a crime or fraud. This prohibition, however, does not preclude the lawyer from giving an honest opinion about the actual consequences that appear likely to result from the client's conduct. Nor does the fact that a client uses advice in a course of action that is criminal or fraudulent of itself make a lawyer a party to the course of action. There is a critical distinction between presenting an analysis of legal aspects of questionable conduct and recommending the means by which a crime or fraud might be committed with impunity. When the client's course of action has already begun and is continuing, the lawyer's responsibility is especially delicate. The lawyer is required to avoid assisting the client, for example, by drafting or delivering documents that the lawyer knows are fraudulent, or by suggesting how the wrongdoing might be concealed. A lawyer may not continue assisting a client in conduct that the lawyer originally supposed was legally proper, but then discovers is criminal or fraudulent. The lawyer must, therefore, withdraw from representation of the client in the matter. See Rule 1.16a. In some cases, withdrawal alone might be insufficient. It may be necessary for the lawyer to give notice of the fact of withdrawal and to disarm any opinion, document, affirmation, or the like. See Rule 4.1. Where the client is a fiduciary, the lawyer may be charged with special obligations in dealings with a beneficiary. Paragraph D applies whether or not the defrauded party is a party to the transaction. Hence, a lawyer must not participate in a transaction to effectuate criminal or fraudulent avoidance of tax liability. Paragraph D does not preclude undertaking a criminal defense incident to a general retainer for legal services to a lawful enterprise. The last clause of paragraph D recognizes that determining the validity or interpretation of a statute or regulation may require a course of action involving disobedience of the statute or regulation, or the interpretation placed on it by government authorities. If a lawyer comes to know or reasonably should know that a client expects assistance not permitted by the rules of professional conduct or other law, or if the lawyer intends to act contrary to the client's instructions, the lawyer must consult with the client regarding the limitations on the lawyer's conduct. Diligence. Rule 1.3. A lawyer shall act with reasonable diligence and promptness in representing a client. Okay. A lawyer should pursue a matter on behalf of a client despite opposition, obstruction, or personal inconvenience to the lawyer, and may take whatever lawful and ethical measures are required to vindicate a client's cause or endeavor. A lawyer must also act with commitment and dedication to the interest of a client. A lawyer is not bound, however, to press for every advantage that might be realized for a client. For example, a lawyer may have authority to exercise professional discretion in determining the means by which a matter should be pursued. See Rule 1.2. The lawyer's duty to act with reasonable diligence does not require the use of offensive tactics or preclude the treating of all persons involved in the legal process with courtesy and respect. A lawyer's workload must be controlled so that each matter can be handled competently. Perhaps no professional shortcoming is more widely resented than procrastination. A client's interests often can be adversely affected by the passage of time or the change of conditions. In extreme instances, as when a lawyer overlooks a statute of limitations, the client's legal position may be destroyed, even when the client's interests are not affected in substance. However, Unreasonable delay can cause a client needless anxiety and undermine confidence in the lawyer's trustworthiness. A lawyer's duty to act with reasonable promptness, however, does not preclude the lawyer from agreeing to a reasonable request for a postponement that will not prejudice the lawyer's client. Unless the relationship is terminated as provided in Rule 1.16, a lawyer should carry through to conclusion all matters undertaken for a client. If a lawyer's employment is limited to a specific matter, the relationship terminates when the matter has been resolved. If a lawyer has served a client over a substantial period in a variety of matters, the client sometimes may assume that the lawyer will continue to serve on a continuing basis unless the lawyer gives a notice of withdrawal. Doubt about whether a client-lawyer relationship still exists should be clarified by the lawyer, preferably in writing, so that the client will not mistakenly suppose the lawyer is looking after the client's affairs when the lawyer has ceased to do so. For example, if a lawyer has handled a judicial or administrative proceeding that produced a result adverse to the client, and the lawyer and the client have not agreed that the lawyer will handle the matter on appeal, the lawyer must consult with the client about the possibility of appeal before relinquishing responsibility for the matter. See Rule 1.482. Whether the lawyer is obligated to prosecute the appeal for the client depends on the scope of the representation the lawyer has agreed to provide to the client. See Rule 1.2. Now, to prevent neglect of client matters in the event of a sole practitioner's death or disability, the duty of diligence may require that each sole practitioner prepare a plan in conformity with applicable rules that designates another competent lawyer to review client files, notify each client of the lawyer's death or disability, and determine whether there is a need for immediate protective action. All right, how's everybody doing? Checking in here, make sure everybody's good in the chat. Chat's all good. Hello, Dan Jones. What's up, Dan Jones? Thank you for coming in. LB, thank you for coming in. Chevy Killer, thank you for coming in. Anyone I missed, thank you for coming in. All right, yo, Critter Mama, hello. We're going to keep going, okay? Thank you, Amy, for reminding everyone. Please do support the channel. Support me at Cash App, Coffee for Prof, or Buy Me a Coffee, the Prof's Crew, or with the super chat or a super sticker or something like that. Thank you for supporting the channel. Also, remember to hit the like or a thumbs up, as I like to call them. Okay, this is very important work, and listen, this is a lot. Okay, this is a lot, but trust me that we haven't even really gotten into it. The more we get into this, the more informed we're all going to become about what we can criticize the various attorneys for, because we will be doing so in the future. So this is, like I said, laying the groundwork here for future discussions. Okay. Communication, Rule 1.4. A lawyer shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent is required by the rules. Reasonably consult with the client about the means by which the client's objectives are to be accomplished. Keep the client reasonably informed about the status of the matter and promptly comply with reasonable requests for information. Consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct or other law or assistance limited under Rule 1.2c. A lawyer shall explain the matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. We'll skip over these because that's all pretty clear. Right. Fees. A lawyer shall not make an agreement for charge or collect an unreasonable fee for an unreasonable amount for expenses. The factors to be considered in determining the reasonableness of a fee include the following: the time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. The likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment by the lawyer, the fee customarily charged in the locality for similar legal services, the amount involved in the results obtained, the time limitations imposed by the client and or by the circumstances, the nature and length of the professional relationship with the client, the experience, reputation, and ability of the lawyer or lawyers performing the services, and whether the fee is fixed or contingent. The scope of the representation and the basis or rate of the fee and expenses for which the client will be responsible shall be communicated to the client, preferably in writing, before or within a reasonable amount of time after commencing the representation, except when the lawyer will charge a regularly represented client on the same basis or rate. Any changes in the basis or rate of the fee or expenses shall be communicated to the client. A fee may be contingent on the outcome of the matter for which the service is rendered, except in a matter in which a contingent fee is prohibited by paragraphs D or other law. The contingent fee agreement shall be in writing, signed by the client, and shall state the method by which the fee is to be determined, including the percentage or percentages that shall accrue to the lawyer in the event of a settlement, trial, or appeal, litigation, and other expenses to be deducted from the recovery, and whether such expenses are to be deducted before or after the contingent fee is calculated. The agreement must clearly notify the client of any expenses for which the client is to be liable, whether or not the client is a prevailing party. Upon conclusion of a contingent fee matter, the lawyer is or shall provide the client with a written statement stating the outcome of the matter, and if there is a recovery, showing the remittance to the client and the method of its determination. A lawyer shall not enter in an arrangement for charge or collect any fee in a domestic relations matter, the payment or amount of which is contingent upon securing of a dissolution or upon the amount of maintenance support, property settlement, or obtaining custody of a child, or a contingent fee for representing a defendant in a criminal case. This provision does not preclude a contract for a contingent fee for legal representation in a domestic relations post-judgment collection action, provided the attorney clearly advises his or her client in writing of the alternative measures available for the collection of such debt, and in all other particulars complies with Professional Conduct Rules 1.5c. A division of a fee between lawyers who are not in the same firm may be made only if the division is in proportion to the services performed by each lawyer, or each lawyer assumes joint responsibility for the representation. The client agrees to the arrangement, including the share each lawyer will receive, and the agreement is confirmed in writing, and the total fee is reasonable. And we'll skip that too because this doesn't really apply for what we're talking about. Rule 1.6, confidentiality of information. Now, this is where you should pay attention because this might actually matter. And I'm talking to you, my friends, who I know are listening. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. So here's paragraph B. A lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary. 1, to prevent reasonably certain death or substantial bodily harm. 2, to prevent the client from committing a crime or from committing fraud that is reasonably certain to result in substantial injury to the financial interest or property of another, and in furtherance of which the client has used or is using the lawyer's services. 3, to prevent, mitigate, or rectify substantial injury to the financial interest or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud, in furtherance of which the client has used the lawyer's services. 4, to secure legal advice about the lawyer's compliance with these rules. 5, to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. To establish a defense to a criminal charge or claim civil action against the lawyer based upon conduct in which the client was involved. Or to respond to allegations in any proceeding concerning the lawyer's representation of the client, or to comply with other law or court order. Thank you, Deb. Thank you very much, Deb. C, in the event of a lawyer's physical or mental disability or the appointment of a guardian or conservator of an attorney's client files, disclosure of a client's name and files is authorized to the extent necessary to carry out the duties of the person managing the lawyer's files. Okay. All right. Rule 1.7, conflict of interest, current clients. Except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client, or there's significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. Okay. Notwithstanding the existence of a concurrent conflict of interest under paragraph A, a lawyer may represent a client if the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. The representation is not prohibited by law. The representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal, and each affected client gives informed consent confirmed in writing. Loyalty and independent judgment are essential elements in the lawyer's relationship to a client. Concurrent conflicts of interest can arise from the lawyer's responsibilities to another client, a former client, or a third person, or from the lawyer's own interest. That's very important. Listen to that again. Listen to that again. Loyalty and independent judgment are essential elements in the lawyer's relationship to a client. Concurrent conflicts of interest can arise from the lawyer's responsibilities to, here are the importance, another client, a former client, or a third person, or from the lawyer's own interest. For specific rules regarding certain concurrent conflicts of interest, see Rule 1.8. For former client conflicts of interest, see Rule 1.9. For conflicts of interest involving prospective clients, see Rule 1.18. For definitions of informed consent and confirmed in writing, see Rule 1.0 E and B. Resolution of a conflict of interest problem under this rule requires the lawyer to 1. Clearly identify the client or clients. 2. Determine whether a conflict of interest exists. Was that 3? 3. Decide whether the representation may be undertaken despite the existence of a conflict, i.e. whether the conflict is consentable. And 4, if so, consult with the clients affected under paragraph A and obtain their informed consent confirmed in writing. The clients affected under paragraph A include both of the clients referred to in paragraph A1 and the one or more clients whose representation might be materially limited under paragraph A2. A conflict of interest may exist before representation is undertaken, in which event the representation must be declined unless the lawyer obtains the informed consent of each client under the conditions of paragraph B. To determine whether a conflict of interest exists, a lawyer should adopt reasonable procedures appropriate for the size and type of firm and practice to determine in both litigation and non-litigation matters the persons and issues involved. See also comment to Rule 5.1. Ignorance caused by a failure to institute such procedures will not excuse a lawyer's violation of this rule. As to whether a client-lawyer relationship exists or having once been established is continuing, see comment to Rule 1.3 in scope. If a conflict arises after representation has been undertaken, the lawyer ordinarily must withdraw from representation unless the lawyer has obtained informed consent of the client under the conditions of paragraph B. See Rule 1.16. Where more than one client is involved, whether the lawyer may continue to represent any of the clients is determined both by the lawyer's ability to comply with the duties owed to the former client and by the lawyer's ability to represent adequately the remaining client or clients, given the lawyer's duties to the former client. See Rule 1.9, also comments 5 and 29. Unforeseeable developments such as changes in corporate and other organizational affiliations or the addition or realignment of parties in litigation might create conflicts in the midst of a representation, as when a company sued by the lawyer on behalf of one of the clients is bought or merged with another client represented by the lawyer in an unrelated matter. Depending on the circumstances, the lawyer may have the option to withdraw from one of the representations in order to avoid the conflict. The lawyer must seek court approval where necessary and take steps to minimize harm to clients. See Rule 1.16, the lawyer must continue to protect confidences of the client from whose representation the lawyer has withdrawn. See Rule 1.9c. All right. Loyalty to a current client prohibits undertaking representation directly adverse to that client without that client's informed consent. Thus, absent consent, a lawyer may not act as an advocate in one matter against a person the lawyer represents in some other matter, even when the matters are wholly unrelated. The client as to whom the representation is directly adverse is likely to feel betrayed, and the resulting damage to the client-lawyer relationship is likely to impair the lawyer's ability to represent the client effectively. In addition, the client on whose behalf the adverse representation is undertaken reasonably may fear that the lawyer will pursue that client's case less effectively out of deference to the other client. That is, that the representation may be materially limited by the lawyer's interest in retaining the current client. Similarly, a directly adverse client or conflict may arise when a lawyer is required to cross-examine a client who appears as a witness in a lawsuit involving another client, as when the testimony will be damaging to the client who is represented in the lawsuit. On the other hand, simultaneous representation in unrelated matters of clients whose interests are only economically adverse, such as representation of competing economic enterprises in unrelated litigation, does not ordinarily constitute a conflict of interest and thus may not require consent of the respective clients. Directly adverse conflicts can also arise in transactional matters. For example, if a lawyer is asked to represent the seller of a business in negotiations with a buyer represented by the lawyer, not in the same transaction, but in another unrelated matter, the lawyer could not undertake the representation without the informed consent of each client. Identifying conflicts of interest, material limitation. Even where there is no direct adverseness, a conflict of interest exists if there's a significant risk that a lawyer's ability to consider, recommend, or carry out an appropriate course of action for the client will be materially limited as a result of the lawyer's other responsibilities or interests. For example, a lawyer asked to represent several individuals seeking to form a joint venture is likely to be materially limited in the lawyer's ability to recommend or advocate all possible positions that each might take because of the lawyer's duty of loyalty to the others. The conflict, in effect, forecloses alternatives that would otherwise be available to the client. The mere possibility of subsequent harm does not itself require disclosure and consent. The critical questions are the likelihood that a difference in interest will eventuate, and if it does, whether it will materially interfere with the lawyer's independent professional judgment in considering alternatives or foreclosure courses or foreclose courses of action that reasonably should be pursued on the behalf of the client. Lawyers' responsibilities to former clients and other third persons. In addition to conflicts with other clients, a lawyer's duties of loyalty and independence may be limited, materially limited, by responsibilities to the former clients under Rule 1.9, or by the lawyer's responsibilities to other persons, such as fiduciary duties arising from a lawyer's service as a trustee, executor, or corporate director. So that's important. I almost want to read that again, but trust me, I don't want to read any of this again because there's a lot of reading. But I think this one is so important. I should point this way. This one's so important. We definitely should read it again, okay? Okay, it says, in addition to conflicts with other or current clients, a lawyer's duties of loyalty and independence may be materially limited by responsibilities to former clients or by the lawyer's responsibilities to other persons, such as fiduciary duties arising from a lawyer's service as a trustee, executor, or corporate director. So, saying that in addition to clients, okay, there may be a conflict of interest that can arise for the lawyer with former clients or any other persons. All right? In other words, it's not only clients. It's not only current clients of the current lawyer we're talking about. Now, that's very important to keep in mind. All right, let's continue. And even furthermore, there's this commentary here. Personal interest conflicts. The lawyer's own interest should not be permitted to have an adverse effect on representation of a client. For example, if the probability well, that's a word I've never heard before. These lawyers like rarely used words or something. If the probity of a lawyer's own conduct in a transaction is in serious question, it may be difficult or impossible for the lawyer to give a client detached advice. Similarly, when a lawyer has discussions concerning possible employment with an opponent of the lawyer's client or with a law firm representing the opponent, such discussions could materially limit the lawyer's representation of the client. In addition, a lawyer may not allow related business interests to affect representation. For example, by referring clients to an enterprise in which the lawyer has an undisclosed financial interest. Let's read that one again. A lawyer may not allow related business interests to affect representation. For example, by referring clients to an enterprise in which the lawyer has an undisclosed financial interest. That would be a personal conflict of interest, even though on its face you wouldn't look at it as a conflict, right? You'd look at it as a benefit. You'd say that this attorney has some undisclosed financial interest in this other enterprise, which he is recommending to the client. You see, but that is still considered a conflict of interest because, yes, it's a conflict of interest because that other enterprise is in his financial interest. Very, very important there. Okay. See Rule 1.8 for specific rules pertaining to a number of personal interest conflicts, including business transactions with clients. See also Rule 1.10, personal interest conflicts under Rule 1.7 ordinarily are not imputed to other lawyers in a law firm. When lawyers representing different clients in the same matter or in substantially related matters or closely related by blood or marriage, there may be a significant risk that the client confidences will be revealed and that the lawyer's family relationship will interfere with both loyalty and independent professional judgment. Oh, oh, really? Really? Should we talk about Brad and Terry German? Can we talk about Brad and Terry German, please? Who's Brad and Terry German? Well, they're the direct relatives of Liberty German. Who was Terry German before she married Brad German? And how was she related to Nicholas McClellan, prosecutor? Thank you, Deb. I learned a new word today. I learned a new word, probity, quality of having strong moral principles, honesty, and decency. Well, I don't know why that should ever be used in a. I don't know why that should ever be used in the terms of attorneys. Remember, lawyers are very close to liars. Lawyers, liar, liar, lawyer, lawyer, liars. I believe probity and lawyers are about as far apart as you could ever imagine. Interesting, they like to throw that term around. All right. But again, let's talk about Terry German's relation to Nicholas McClelland. Again, this says close family relationship. All right. The disqualification arising from a close family relationship is personal and ordinarily is not imputed to members or firms with whom the lawyers are associated. A lawyer is prohibited from engaging in relationships of a sexual nature with a client unless the sexual relationship with the client predates the formation of the client-lawyer relationship. We'll skip over this. Interest of a person paying for a lawyer's services. Okay. All right, I'm just looking to get past this because we are now we're going to rule 1.8, conflict of interest, current client specific rules. A lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest in adverse to a client, unless the transaction and terms on which the lawyer acquires the interest are fair and reasonable to the client and are fully disclosed and transmitted in writing in a manner that can be reasonably understood by the client. The client is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of independent legal counsel on the transaction. And the client gives informed consent in writing signed by the client to essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. A lawyer shall not use information relating to representation of a client to the disadvantage of the client unless the client gives informed consent, except as permitted or required by these rules. A lawyer shall not solicit any substantial gift from a client, including a testamentary gift, or prepare on behalf of a client an instrument giving the lawyer or a person related to the lawyer any substantial gift unless the lawyer or other recipient of the gift is related to the client. For the purposes of this paragraph, related persons include a spouse, child, grandchild, parent, and grandparent, or other relative or individual with whom the lawyer or client maintains a close familial relationship. Prior to the conclusion of representation of a client, a lawyer shall not make or negotiate an agreement giving the lawyer literary or media rights to or portrayal or account based in substantial part on information relating to the representation. That's very interesting. Let's read that one again. Read this one again, y'all. I will read it for you. Prior to the conclusion of representation of a client, a lawyer shall not make or negotiate. Remember that word, shall not? That means this is non-negotiable. Shall not. This is a rule, not a request. A lawyer shall not make or negotiate an agreement giving the lawyer literary or media rights to a portrayal or account based in substantial part on information relating to the representation. Dodged a bullet there, didn't we? A lawyer shall not, another shall, right? A lawyer shall not provide financial assistance to a client in connection with pending or contemplated litigation, except that the lawyer may advocate court costs and expenses of litigation, the repayment of which may be contingent on the outcome of the matter. A lawyer representing an indigent client may pay court costs and expenses of litigation on behalf of the client. A lawyer shall not accept compensation for representing a client from one other than the client, unless the client gives informed consent, unless there's no interference with the lawyer's independence of professional judgment or with the client-lawyer relationship, and unless information relating to the representation of a client is protected as required by Rule 1.1. A lawyer who represents two or more clients shall not participate in making an aggregate settlement of the claims of or against the clients, or in a criminal case, an aggregate agreement as to guilty or nolo contender pleas, unless each client gives informed consent in a writing signed by the client. The lawyer's disclosure shall include the existence and nature of all the claims or pleas involved and the participation of each person in the settlement. A lawyer shall not make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making the agreement. A lawyer shall not settle a claim or potential claim for such liability with an unrepresented client or former client unless that person is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek advice of independent legal counsel in connection therewith. A lawyer shall not acquire a proprietary interest in the cause of action or subject matter of litigation the lawyer is conducting for a client. Let's read that again. A lawyer shall not acquire a proprietary interest in the cause of action or subject matter of litigation the lawyer is conducting for a client, except that the lawyer may acquire a lien authorized by law to secure the lawyer's fees or expenses and contract with the client for a reasonable contingent fee in a civil case. A lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. We don't have to worry about that with our lawyers, right? Because our lawyers are incels. They're not sexually active lawyers. Good thing for Delphi. Okay, these lawyers ain't getting laid. So let's see. While lawyers are associated in a firm, a prohibition in paragraphs A through I and L that applies to any one of them shall apply to all of them. A part-time prosecutor or deputy prosecutor authorized by statute to otherwise engage in the practice of law shall refrain from representing a private client in any matter wherein exists an issue upon which said prosecutor has statutory prosecutorial authority or responsibilities. This restriction is not intended to prohibit representation in tort cases in which investigation and any prosecution of infractions has terminated, nor to prohibit representation in family law matters involving no issue subject to prosecutorial authority or responsibilities. Upon a prior express written limitation of responsibility to exclude prosecutorial authority in matters related to family law, a part-time deputy prosecutor may fully represent a private clients in cases involving family law. All right. All right, y'all. We'll skip all of this because, I want to read this one. I'll skip the rest. Literary rights. The commentary on literary rights states as follows. An agreement by which a lawyer acquires literary or media rights concerning the conduct of the representation creates conflict between the interest of the client and the personal interest of the lawyer. Measures suitable in the representation of the client may detract from the publication value of an account of the representation. Paragraph D does not prohibit a lawyer from representing a client in a transaction concerning literary property from agreeing that the lawyer's fee shall consist of a share in ownership in the property, if the arrangement conforms to Rule 1.5 in paragraphs A and 1. Or A and I. Was that I? Well, let's continue. Duties to former clients, Rule 1.9. A lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client unless the former client gives informed consent confirmed in writing. A lawyer shall not knowingly represent a person in the same or a substantially related matter in which a firm with which the lawyer formerly was associated had previously represented a client whose interests are materially adverse to that person, and about whom the lawyer had acquired information protected by Rules 1.6 and 1.9c that is material to the matter, unless the former client gives informed consent confirmed in writing. A lawyer who has formerly represented a client in a matter whose present or former firm has formerly represented a client in a matter shall not thereafter use information relating to the representation to the disadvantage of the former client, except as these rules will permit or require with respect to a client, or when the information has become generally known, or reveal information relating to the representation accepted as these rules would permit or require with respect to a client. Okay. Imputation of conflicts of interest, general rule, Rule 1.10. While lawyers are associated in a firm, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so by Rules 1.7, 1.9, or 2.2, unless the prohibition is based upon personal interest of the prohibited lawyer and does not represent a significant risk of materially limiting the representation of the client by the remaining lawyers in the firm. Well, I wonder if that would apply to prosecutors. If McClellan had a conflict of interest in being related, although by marriage, to the victim's family in the Delphi murders, would that then preclude him and all other prosecutors working on behalf of Carroll County from working the prosecution as they did? Why has no one made any noise about that? Seriously, why has it not come up? Why has the media failed to do their job, right? Why have our so-called Delphi journalists, which don't exist, as we know, let's be honest here, we are the journalist, okay? We are the journalist, right? Let me remove this, and I know this is going to piss off some mean girls. Look, as we all well know, we are the journalist, okay? Because we know that everyone proclaiming to themselves to be journalists are not actually journalists on this case. The mainstream media have not been journalists on this case. And apparently no one has done any work in this direction. Why has no one spoken out about it? Why did the defense attorneys not bring this up? Is this perhaps a matter for private attorneys of Mrs. Kathy Allen? Maybe Mrs. Kathy Allen needs her personal attorneys to look into the matter regarding a potential conflict of interest of not only Nick McClellan, but if this rule applies to prosecutors as well, then that would mean that here Rule 110A, that there's a conflict of interest with McClellan, then there's a conflict of interest with all of the prosecutors, right? Anyway, moving on. When a lawyer becomes associated with a firm, no lawyer associated with the firm shall knowingly represent a person in a matter in which that lawyer is disqualified under Rule 1.9. Unless the personally disqualified lawyer did not have primary responsibility for the matter that caused the disqualification. The personally disqualified lawyer is timely screened from any participation in the matter and is apportion no part of the fee therefrom, and written notice is promptly given to any affected former client to enable it to ascertain compliance with the provision of this rule. A disqualification prescribed by this rule must be waived or may be waived by the affected client under the conditions stated in Rule 1.7. The disqualification of lawyers associated in a firm with former or current government lawyers is governed by Rule 111. Definition of firm. For the purposes of rules of professional conduct, the term firm denotes lawyers in a law partnership, professional corporation, sole proprietorship, or other association authorized to practice law, or lawyers employed in a legal services organization or the legal department of a corporation or other organization. See Rule 1.0c. Whether two or more lawyers constitute a firm within this definition can depend on the specific facts. See Rule 1.0 comments 2 to 4. Principles of imputed disqualification. The rule of imputed disqualification stated in paragraph A above gives effect to the principle of loyalty to the client as it applies to lawyers who practice in a law firm. Such situations can be considered from the premise that a firm of lawyers is essentially one lawyer for the purposes of the rules governing loyalty to the client, or from the premise that each lawyer is vicariously bound by the obligation of loyalty owed by each lawyer with whom the lawyer is associated. Paragraph A operates only among the lawyers currently associated in a firm. When a lawyer moves from one firm to another, the situation is governed by Rules 1.9b and 1.10b and 1.10c. The rule in paragraph A does not prohibit representation where neither questions of client loyalty nor protection of confidential information are presented. All right, we're going to skip ahead. I want to get on to Rule 111. Special conflicts of interest for former and current government officers and employees. Except as law may otherwise expressly permit, a lawyer who has formerly served as a public officer or employee of the government is subject to Rule 1.9c and shall not otherwise represent a client in connection with the matter in which the lawyer participated personally and substantially as a public officer or employee, unless appropriate government agency gives its informed consent, confirmed in writing, to the representation. When a lawyer is disqualified from representation under paragraph A, no lawyer in the firm with which that lawyer is associated may knowingly undertake or continue representation in such a matter unless the disqualified lawyer is timely screened. So see, it is the same. So you get this, what I'm saying here, this right here, for former and current government officers, employees, that would be Prosecutor Nicholas McClellan, right? This would be the prosecutor's office, right? Current government officers and employees. So it's repeating the same rules as 110 that we just read for firm and conflicts of interest. It goes the same for 111 for government employees. So that was correct. Except as law may otherwise expressly permit, a lawyer having information that the lawyer knows is confidential government information about a person acquitted or about a person acquired when the lawyer was a public officer or employee may not represent a private client whose interests are adverse to that person in a matter in which the information could be used to the material disadvantage of that person. As used in this rule, the term confidential government information means information that has been obtained under governmental authority, in which at the time this rule is applied, the government is prohibited by law from disclosing to the public, or is a legal privilege not to disclose and which is not otherwise available to the public. A firm with which that lawyer is associated may undertake or continue representation in the matter only if the disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom. Right. Except as law may otherwise expressly permit, a lawyer currently serving as public officer or employee is subject to Rules 1.7 and 9 and shall not, 1, participate in a matter in which the lawyer participated personally and substantially while in private practice or non-governmental employment unless the appropriate government agency gives its informed consent confirmed in writing, or negotiate for private employment with any person who is involved as a party or as a lawyer for a party in a matter in which the lawyer is participating personally and substantially, except that a lawyer serving as a law clerk to a judge, other adjudicative officer, or arbitrator may negotiate for private employment as permitted by Rule 1.12b and subject to conditions stated in 1.12b. As used in this rule, the term matter includes any judicial or other proceeding, application, request for ruling or other determination, contract, claim, controversy, investigation, charge, accusation, arrest, or other particular matter involving a specific party or parties, and any other matter covered by the conflict of interest rules of the appropriate government agency. All right. Former judge, arbitrator, mediator, or other third party neutral, Rule 1.12. Except if stated in paragraph D, a lawyer shall not represent anyone in connection with a matter in which the lawyer participated personally and substantially as a judge or other adjudicative officer, arbitrator, mediator, or other third party neutral or law clerk to such a person, unless all parties to the proceeding give informed consent confirmed in writing. A lawyer shall not negotiate for employment with any person who is involved as a party or as lawyer for a party in a matter in which the lawyer is participating personally and substantially as a judge or other adjudicative officer, or as an arbitrator, mediator, or third party neutral. A lawyer serving as a law clerk to any such person may negotiate for employment with a party or lawyer involved in a matter in which the clerk is participating personally and substantially, but only after the lawyer has notified the law clerk's employer. If a lawyer is disqualified by paragraph 8, no lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in the matter, unless the disqualified lawyer is timely screened from any participation in the matter, and is proportioned no part of the fee therefrom, and written notice is promptly given to the parties in any appropriate tribunal to enable them to ascertain compliance with the provisions under this rule. An arbitrator selected as partisan of a party in a multi-member arbitration panel is not prohibited from subsequently representing that party. Rule 1.13, organization as client. A lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents. If a lawyer for an organization knows that an officer, employee, or other person associated with the organization is engaged in action, intends to act, or refuses to act in a matter related to the representation that is a violation of a legal obligation to the organization, or a violation of law which reasonably might be imputed to the organization, and that it is likely to result in substantial injury to the organization, then the lawyer shall proceed as is reasonably necessary in the best interest of the organization, unless the lawyer reasonably believes that it is not necessarily in the best interest of the organization to do so. If the lawyer shall refer the matter to the higher authority in the organization, including, if warranted by the circumstances, to the highest authority that can act on behalf of the organization as determined by applicable law. Except as provided in paragraph D, if one, despite the lawyer's efforts in accordance with paragraph B, the highest authority that can act on behalf of the organization, insists upon or fails to address in a timely and appropriate manner an action or a refusal to act that is clearly a violation of law, and the lawyer reasonably believes that the violation is reasonably certain to result in substantial injury to the organization, then the lawyer may reveal information relating to the representation whether or not Rule 1.6 permits such disclosure, but only if and to the extent the lawyer reasonably believes necessary to prevent substantial injury to the organization. Now, paragraph C shall not apply with respect to information relating to a lawyer's representation of an organization to investigate an alleged violation of law or to defend an organization or an officer, employee, or other constituent associated with the organization against a claim arising out of an alleged violation of law. A lawyer who reasonably believes that he or she has been discharged because of the lawyer's actions taken pursuant to paragraphs B or C, or who withdraws under circumstances that require or permit the lawyer to take action under either of those paragraphs, shall proceed as the lawyer reasonably believes necessary to assure that the organization's highest authority is informed of the lawyer's discharge or withdrawal. In dealing with an organization's directors, officers, employees, members, shareholders, or other constituents, a lawyer shall explain the identity of the client when the lawyer knows or reasonably should know that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. A lawyer representing an organization may also represent any of its directors, officers, employees, members, shareholders, or other constituents subject to the provisions of Rule 1.7 if the organization's consent to the dual representation is required by Rule 1.7. Consent shall be given by an appropriate official of the organization other than the individual who is to be represented or by the shareholders. Rule 1.14, client with diminished capacity. Ooh. When a client's capacity to make adequately considered decisions in connection with the representation is diminished, whether because of minority, mental impairment, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. When the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interests, the lawyer may take reasonable, necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. Information relating to the representation of a client with diminished capacity is protected by Rule 1.6. When taking protective action pursuant to paragraph B, the lawyer is impliedly authorized under Rule 1.6a to reveal information about the client, but only to the extent reasonably necessary to protect the client's interests. This rule is not violated if the lawyer acts in good faith to comply with this rule. The normal client-lawyer relationship is based on the assumption that the client, when properly advised and assisted, is capable of making decisions about important matters. When the client is a minor or suffers from a diminished mental capacity, however, maintaining the ordinary client-lawyer relationship may not be possible in all respects. In particular, a severely incapacitated person may have no power to make legally binding decisions. Nevertheless, a client with diminished capacity often has the ability to understand, deliberate upon, and reach conclusions about matters affecting the client's own well-being. For example, children as young as 5 or 6 years of age, and certainly those of 10 or 12, are regarded as having opinions that are entitled to weight in legal proceedings concerning their custody. So also, it is recognized that some persons of advanced age can be quite capable of handling routine financial matters while needing specific legal or special legal protection concerning major transactions. The fact that a client suffers a disability does not diminish the lawyer's obligation to treat the client with attention and respect. Even if the person has a legal representative, the lawyer should, as far as possible, accord the represented person the the status of client, particularly in maintaining communication. The client may wish to have family members or other persons participate in discussions with the lawyer. When necessary to assist with the representation, the presence of such persons generally does not affect the applicability of the attorney-client evidentiary privilege. Nevertheless, the lawyer must keep the client's interests foremost, and except for protective action authorized under paragraph B, must look to the client and not family members to make decisions on the client's behalf. If a legal representative has already been appointed for the client, the lawyer should ordinarily look to the representative for decisions on behalf of the client. In matters involving a minor, whether the lawyer should look to the parents as natural guardians may depend on the type of proceeding or matter in which the lawyer is representing the minor. If the lawyer represents the guardian as distinct from the ward and is aware that the guardian is actively or acting adversely to the ward's interests, the lawyer may have an obligation to prevent or rectify the guardian's misconduct. See Rule 1.2d. Okay. Rule 1.15. Safekeeping property. A lawyer shall hold property of clients or third persons that is in a lawyer's possession in connection with a representation separate from the lawyer's own property. Funds shall be kept in a separate account, maintained in the state where the lawyer's office is situated, or elsewhere with the consent of the client or third person. Other property shall be identified as such and appropriately safeguarded. Complete records of such account funds and other property shall be kept by the lawyer and shall be preserved for a period of 5 years after termination of the representation. A lawyer may deposit his or her own funds reasonably sufficient to maintain a nominal balance in a client trust account. A lawyer shall deposit into a client trust account legal fees and expenses that have been paid in advance, to be withdrawn by the lawyer only as fees are earned or expenses occurred or incurred. Upon receiving funds or other property in which the client or third person has an interest, a lawyer shall promptly notify the client or third person. Except as stated in this rule or otherwise permitted by law or by agreement with the client, a lawyer shall promptly deliver to the client or third person any funds or other property that the client or third person is entitled to receive, and upon request by the client or third person, shall promptly render a full accounting regarding such property. When in the course of representation a lawyer is in possession of property in which two or more persons, one of whom may be the lawyer, claim interests, the property shall be kept separate by the lawyer until the dispute is resolved. The lawyer shall promptly distribute all portions of the property as to which the interests are not in dispute. Except as provided in paragraph G of this rule, a lawyer or firm shall create and maintain an interest-bearing trust account for clients' funds which are nominal in amount or to be held for a short period of time so that they could not earn income for the client in excess of the cost incurred to secure such income. Hereinafter sometimes referred to as an EOLTA account, in compliance with the following provisions. Clients' funds shall be deposited in a lawyer's or law firm's EOLTA account unless the funds can earn income for the client in excess of the costs incurred to secure such income. A lawyer or law firm shall establish a separate interest-bearing trust account for the client's funds, which are neither nominal in amount nor to be held for a short period of time, and which could earn income for the client in excess of the cost for a particular client or client's matter. All of the interest on such account, net of any transaction cost, shall be paid to the client, and no earnings from such account shall be made available to a lawyer or law firm. No earnings from such an EIOLTA account shall be made available to a lawyer or law firm. The EIOLTA account shall include all clients' funds which are nominal in amount or to be held for a short period of time. An EIOLTA account may be established with any financial institution authorized by federal or state law to do business in Indiana, insured by the Federal Deposit Insurance Corporation or its equivalent, and approved as a depository for trust accounts pursuant to Indiana Admission and Discipline Rules, Rule 23, Section 29. Funds in each EIOLTA account shall be subject to withdrawal upon request and without delay and without risk to principal by reason of said withdrawal. Participating financial institutions shall maintain EIOLTA accounts which pay the highest interest rate or dividend generally available from the institution to its non-EIOLTA account customers when EIOLTA accounts meet or exceed the same minimum balance or other account eligibility qualifications, if any. In determining the highest interest rate or dividend generally available from the institution to its non-EIOLTA accounts, eligible institutions may consider factors in addition to the EIOLTA account balance customarily considered by the institution when settling interest rates or dividends for its customers, provided that such factors do not discriminate between EIOLTA accounts and accounts of non-EIOLTA customers, and that these factors do not include that the account is an EIOLTA account. All interest earned net of fees or charges shall be remitted to the Indiana Bar Foundation, the foundation, which is designated in paragraph 1 or paragraph I of this rule, to organize and administer the EIOLTA program. And the depository institution shall submit reports thereon as set forth below. Lawyers or law firms depositing client funds in an EIOLTA account established pursuant to this rule shall, on forms approved by this foundation, direct the depository institution, A, to remit all interest or dividends, net of reasonable service charges or fees, if any, on the average monthly balance in the account, or as otherwise computed in accordance with the institution's standard accounting practice, at least quarterly, solely to the foundation. The depository institution may remit the interest or dividends on all of its EIOLTA accounts in a lump sum. However, the depository institution must provide for each individual EIOLTA account the information to the lawyer or law firm and to the foundation required by subparagraphs F6B and F6C of this rule. B, to transmit with each remittance to the foundation a statement showing the name of the lawyer or law firm for whom the remittance is sent, the rate of interest applied, and other such information as is reasonably required by the foundation. C, to transmit to the depositing lawyer or law firm a periodic account statement for the EIOLTA account reflecting the amount of interest paid to the foundation, the rate of interest applied, the average account balance for the period for which the interest was earned, and other such information as is reasonably required for the foundation. And D, to waive any reasonable service charge that exceeds the interest earned on any EIOLTA account during the reporting period, excess charge, or bill the excess charge to the foundation. Any EIOLTA account which has or may have the net effect of costing the EIOLTA program more in fees than earned in interest over a period of time may, at the discretion of the foundation, be exempted from and removed from the EIOLTA program. Exemption of an EIOLTA account from the EIOLTA program revokes the permission to use the foundation's tax identification number for that account. Exemption of such account from the EALTA program shall not relieve the lawyer and or law firm from the obligation to maintain the property of clients and third persons separately as required above in a non-interest bearing account. The EALTA program will issue refunds when interest has been remitted in error, whether the error is the bank's or the lawyer's. Requests for refunds must be submitted in writing by the bank, the lawyer, or law firm on a timely basis, accompanied by documentation that confirms the amount of interest paid to the program as needed for auditing purposes. The EALTA program may request additional documentation to support the request. The refund will be remitted to the appropriate financial institution for transmittal at the lawyer's direction after appropriate accounting and reporting. In no event will the refund exceed the amount of interest actually received by the EALTA program. All funds transmitted to the foundation pursuant to this rule shall be held, invested, and distributed periodically in accordance with the plan of distribution, which shall be prepared by the foundation and approved at least biennially by the Supreme Court of Indiana for the following purposes: to pay for or provide for all costs, expenses, and fees associated with administration of the funds under this rule, to establish appropriate reserves, to support civil legal assistance and pro bono programs in Indiana, and for such other programs for the benefit of the public as are specifically approved by the Supreme Court from time to time. The information contained in the statements forwarded to the foundation under subparagraph F6 of this rule shall remain confidential, and the provisions of Rule 1.6, confidentiality of information, are not hereby abrogated. Therefore, the foundation shall not release any information contained in any such statement other than as a compilation of data from such statements, except as directed in writing by the Supreme Court. The foundation shall have the full authority to and shall from time to time prepare and submit to the Supreme Court for approval forms, procedures, instructions, and guidelines necessary and appropriate to implement the provisions set forth in this rule, and after approval thereof by the court shall promulgate same. Every lawyer admitted to practice in the state shall annually certify to this court, pursuant to Indiana Admis Disc R at 2F, that all client funds which are nominal in amount or to be held for a short period of time by a lawyer or the lawyer's firm so that they could not earn income for the client in excess of the cost incurred to secure such income, or held in an EALTA account, or that the lawyer is exempt because the lawyer or law firm's client trust account has been exempted and removed from the EALTA program by the foundation pursuant to subparagraph F7 of this rule, or the lawyer A is not engaged in private practice of law, is not engaged in private practice of law in Indiana that involves holding client or third-party funds in trust, does not have an office in the state of Indiana, is a judge, attorney general, public defender, U.S. attorney, district attorney on duty with the armed services, or employed by local, state, or federal government, and is not otherwise engaged in private practice of law, is a corporate counsel or teacher of law and not otherwise engaged in the private practice of law, has been exempted by an order of general or special application of this court, which is cited in the certification, or compliance with paragraph F would work an undue hardship on the lawyer, would be extremely impractical based either on the geographic distance between the lawyer's principal office and the closest depository institution which is participating in the program, or other compelling and necessitous factors. In the exercise of a lawyer's good faith judgment and determining whether funds of a client can earn income in excess of costs, a lawyer shall take into consideration the following factors: the amount of interest which the funds would earn during the period they're expected to be deposited, cost of establishing and administering the account, including the cost of lawyer services, accounting fees, and tax reporting costs and procedures, the capability of a financial institution, a lawyer, or a law firm to calculate and pay income to individual clients, any other circumstances that affect the ability of the client's funds to earn a net return for the client, and the nature of the transaction involved Determination of whether a client's funds are nominal or short-term so that they could not earn income in excess of all costs shall rest in the sound judgment of the lawyer or law firm. No lawyer shall be charged with an ethical impropriety or other breach of professional conduct based on the good faith exercise of such judgment. The foundation is hereby designated as the entity to organize and administer the IOLTA program established by paragraph F of this rule in accordance with the following provisions. The board of directors of the foundation, the board, shall have general supervisory authority over the administration of the IOLTA program, subject to continuing jurisdiction of the Supreme Court. The board shall receive the net earnings from IOLTA accounts established in accordance with paragraph F of this rule and shall make appropriate temporary investments in the IOLTA program funds pending disbursement of such funds. The board shall, by grants, appropriations, and other appropriate measures, make disbursements from the IOLTA program funds, including current and accumulated net earnings in accordance with the plan of distribution approved by the Supreme Court from time to time, referenced in subparagraph F9 of this rule. The board shall maintain proper records of all IOLTA program receipts and disbursements, which records shall be audited or reviewed annually by certified public accountant selected by the board. The board shall annually cause to be presented to the Supreme Court a reviewed or audited financial statement of its IOLTA program receipts and expenditures for the prior year. The report shall not identify any clients or lawyers or law firms or reveal confidential information. The statement shall be filed with the clerk of the Supreme Court, and a summary thereof shall be published in the next available issue of one or more statewide publication for attorneys, such as the Res Geste and the Indiana Lawyer. President and other members of the board shall administer the IOLTA program without compensation, but may be reimbursed for their reasonable and necessary expenses incurred in the performance of their duties and shall be indemnified by the foundation against any liability or expense arising directly or indirectly out of the good faith performance of their duties. The board shall monitor attorney compliance with the provisions of this rule and periodically report to the Supreme Court those attorneys not in compliance with the provisions of Rule 1.15. In the event the IOLTA program or its administration by the foundation is terminated, all assets of the IOLTA program, including any program funds then on hand, shall be transferred in accordance with the order of the Supreme Court terminating the IOLTA program or its administration by the foundation, provided such transfer shall be an entity which will not violate the requirements the foundation must observe regarding the transfer of its assets in order to retain its tax-exempt status under the IRS Code of 1986 as amended for similar future provisions of law. A lawyer, law firm, or estate of a deceased lawyer with unclaimed or identified funds in the client trust account shall take reasonable efforts to locate and distribute funds to the owner. Unclaimed funds or monies which a lawyer or firm is holding in a client trust account that should be distributed to a client or third party. Unidentified funds or monies for which the lawyer or firm cannot identify an owner. If a lawyer, law firm, or estate of a deceased lawyer cannot identify or locate the owner of funds in its IOLTA or non-IOLTA trust account, it shall pay the funds to the Indiana Bar Foundation for use in accordance with this rule. Once the lawyer or law firm has an obligation to pay or distribute these funds, the lawyer or law firm has a period of 5 years to identify or locate the owner of the funds. A lawyer's or law firm's reasonable efforts to identify the owners of the funds include a review of transaction records, client ledgers, case files, and any other relevant fee records. Reasonable efforts to locate the owner of the funds include periodic correspondence of the type contemplated by the lawyer's or law firm's relationship with the client, former client, or third party. Such correspondence should such correspondence prove unsuccessful, lawyers or firms reasonable efforts to include efforts similar to those that would be undertaken when attempting to locate a person for service of process, such as examinations of the local telephone directories, courthouse records, voter registration records, local tax records, motor vehicle records, or the use of consolidated online search services that access such records. A lawyer or law firm or lawyer's estate shall certify those reasonable efforts to locate or identify the owners before remitting such fund to the Indiana Bar Foundation. At the time such funds are remitted, the lawyer shall submit to the Indiana Bar Foundation the name and last known address of each person appearing from the lawyer's or law firm's records to be entitled to the funds if known, along with the amount of any unclaimed or unidentified funds. If within 5 years of remitting unclaimed or unidentified funds to the Indiana Bar Foundation, the lawyer, law firm, or deceased lawyer's estate identifies and locates the owner of the funds paid, the Indiana Bar Foundation shall refund the sum to the lawyer, law firm, or deceased lawyer's estate. The lawyer, law firm, or deceased lawyer's estate shall submit to the foundation a verification attesting that the funds have been returned to the owner. The Indiana Bar Foundation shall maintain sufficient reserves to pay all claims for such funds. A lawyer's or law firm's remittance to the Indiana Bar Foundation under this paragraph H shall not constitute misconduct or grounds for discipline if the lawyer or law firm exercised reasonable efforts to locate the owner and distribute the funds and remitted the funds to the Indiana Bar Foundation in good faith. A lawyer or law firm's duty to locate the owner of unclaimed funds shall terminate once they have made reasonable efforts to locate the owner of those funds for a period of 5 years and they have remitted the funds to the Indiana Bar Foundation. A lawyer or law firm shall include a provision in its engagement letter or fee agreement describing this rule, 1.15 process for unclaimed and unidentified funds. It is professional misconduct under Rule 8.4 of the Indiana's Rule for Professional Conduct for a lawyer or law firm to remit unidentified or unclaimed funds to the foundation prior to making reasonable efforts to locate the owner and distribute the funds. Okay. We'll skip these comments. All right, guys, we may just be stopping here. Okay, I think we may be stopping here. Okay, so we're going to read this one. Rule 1.16, declining or terminating representation. Except as stated in paragraph C, a lawyer shall not represent a client, or where representation has commenced, shall withdraw from the representation of a client if the representation will result in violation of the rules of professional conduct or other law. Oh, that's pretty clear. Two, the lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client, or the lawyer is discharged. Except as stated in paragraph C, a lawyer may withdraw from representing a client if withdrawal can be accomplished without material adverse effect on the interest of the client. Client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. The client has used the lawyer's services to perpetrate a crime or fraud. A client insists upon taking action that a lawyer considers repugnant or with which the lawyer has a fundamental disagreement. The client fails substantially to fulfill an obligation to the lawyer regarding the lawyer's services and has been given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. The representation will result in an unreasonable financial burden on the lawyer, or has been rendered unreasonably difficult by the client, or other good cause for withdrawal exists. A lawyer must comply with applicable law requiring notice to or permission of a tribunal when terminating a representation. When ordered to do so by a tribunal, a lawyer shall continue representation notwithstanding good cause for terminating the representation. Upon termination of representation, a lawyer shall take steps to the extent reasonably practicable to protect a client's interest, such as giving reasonable notice to the client, allowing time for the employment of other counsel, surrendering papers or property to which the client is entitled, and refunding any advance payments of fees or expenses that have not been earned or incurred. The lawyer may retain papers relating to the client to the extent permitted by other law. A lawyer should not accept representation in a matter unless it can be performed competently, promptly, without improper conflict of interest, and to completion. Ordinarily, a representation is a matter completed, uh, and it is completed when the agreed upon assistance has been concluded. Mandatory withdrawal. A lawyer ordinarily must decline or withdraw from representation if the client demands that the lawyer engage in conduct that is illegal or violates the rules of professional conduct or other law. The lawyer is not obliged to decline or withdraw simply because the client suggests a course of conduct. A client may make a suggestion in the hope that the lawyer will not be constrained by professional obligation. When a lawyer has been appointed to represent a client, withdrawal ordinarily requires approval of the appointing authority. Now that's interesting. You guys think of this. We're going to go on a little detour here. And listen, here's the first thing a certain someone's going to say. Another bad legal take from the king of transparency and truth in Delphi. Or he's going to say, another bad legal take from the prof. This is not a bad legal take. This is a question, okay? This is interesting. The quotation being, when a lawyer has been appointed to represent a client, which Baldwin and Rozzi were, correct? Baldwin and Rozzi were appointed public defenders. Withdrawal ordinarily requires approval of the appointing authority. Is it true? Is it true that the Indiana Public Defender's Office must approve the withdrawal? So the question being, did Amy Carozzo's or did the Indiana Public Defender's Office approve of Baldwin and Rozzi withdrawing their representation at that in-chambers meeting? I don't know, but this is what this looks like, so let's continue. When a lawyer has been appointed to represent a client, withdrawal ordinarily requires the approval of the appointing authority. See also Rule 6.2. Well, we will. Similarly, court approval or notice to the court is often required by applicable law before a lawyer withdraws from pending litigation. A difficulty may be encountered if withdrawal is based on the client's demand that the lawyer engage in unprofessional conduct. The court may request an explanation for the withdrawal, while the lawyer may be bound to keep confidential the facts that would constitute such an explanation. The lawyer's statement that professional considerations require termination of the representation ordinarily should be accepted as sufficient. Lawyers should be mindful of their obligations to both clients and the court under Rules 1.6 and 3.3. A client has a right to discharge any lawyer at any time, with or without cause, subject to liability for payment for the lawyer's services. Where a future dispute about the withdrawal may be anticipated, it may be advisable to prepare a written statement reciting the circumstances. Whether a client can discharge appointed counsel may depend on applicable law. A client seeking to do so should be given a full explanation of the consequences. These consequences may include a decision by the appointing authority that the appointment of successor counsel is unjustified, thus requiring self-representation by the client. If the client has severely diminished capacity, the client may lack legal capacity to discharge the lawyer. And in any event, the discharge may seriously be adverse to the client's interest. A lawyer should make special effort to help the client consider the consequences and may take reasonably necessary protective action as provided in Rule 1.14. Optional withdrawal. A lawyer may withdraw from representation in some circumstances. The lawyer has the option to withdraw if that can be accomplished without material adverse effect on the client's interest. Withdrawal is also justified if the client persists in a course of action that the lawyer reasonably believes is criminal or fraudulent. For a lawyer is not required to be associated with such conduct even if the lawyer does not further it. Withdrawal is also permitted if the lawyer's services were misused in the past, even if that would materially prejudice the client. The lawyer may also withdraw where the client insists on taking action that the lawyer considers repugnant, or with which the lawyer has a fundamental disagreement. A lawyer may withdraw if a client refuses to abide by the terms of an agreement relating to the representation, such as an agreement concerning fees or court costs, or an agreement limiting the objectives of representation. Assisting the client upon withdrawal. Even if the lawyer has been unfairly discharged by the client, a lawyer must take all reasonable steps to mitigate the consequences to the client. The lawyer may retain papers as a security for a fee only to the extent permitted by law. See Rule 1.15. Okay, so now I want to go back and revisit this here, where it's cited. What was it? Rule 6.2. Okay, so let's go to 6.2. I see. And that was 1.16, I believe. Let's read this again, reference 6.2. When a lawyer has been appointed to represent a client, withdrawal ordinarily requires approval of the appointing authority. See Rule 6.2. Okay, let's go to 6.2 again. A lawyer shall not seek to avoid appointment by tribunal to represent a person except for good cause, as when representing a client is likely to result in violation of the rules, representing the client is likely to result in unreasonable financial burden, the client or cause is so repugnant to the lawyer as to be likely to impair the client-lawyer relationship. All right, well, for all of you here, I think that's enough reading for my throat tonight. I'm feeling it. It's a little bit much for me. But we'll finish up with this tomorrow, hopefully. Hopefully tomorrow we will do a part 2 of this, if I'm able to. The professionals, right? The lawyers. We're talking about the lawyers. We're talking about the rule book, the guidelines, the friendly suggestions. And I think there's already some things in there we've covered tonight that we need to be thinking about. And I'm sure, matter of fact, I'm absolutely positive that there's more to come.